Hello, my name is Joshua Curtis, and today I'm going to be talking about some changes to probate law that came out of House Bill 2445. Today is May 7th, 2026. This goes into effect on June 11th, 2026. So most of these changes affected probates that do not have a will for the deceased. So these are intestate estates. The person who's appointed as personal representative is the administrator of the estate. And the proof that they have been appointed are that the court issues letters of administration. So that's the administrator or personal representative's proof that they've been appointed is called letters of administration. And there's some new rules about how they get their letters and what they have to do after they get them, and some changes involving who can apply, who can petition the court to get letters of administration. So we'll jump right in with these changes here. The first is our changes to the petition itself. This is the document that starts it. This is where you're asking the court to appoint you as the personal representative of the estate. So there's a new requirement that the petition has to include a statement that the deceased died without a will. That would be typical from before, but now you have to include a statement about the petitioner's basis for that knowledge. So why they believed that the petitioner, or why they believe that the deceased didn't have a will. So it could be that you searched their records, you found other important documents, there were no wills there, things like that. Just a declaration about what efforts the petitioner did to try and find a will. Second is you must include details about your search for heirs. So sometimes we're dealing with family members who know the family tree, and that's easy, to get everybody's, names and addresses and things. Other times, it could be extended family because of deaths and things in the family, and we're looking all over, hiring private investigators or whatever to try and find these heirs. So you have to give a statement about what type, what you've done for that search for heirs. If the petitioner isn't a surviving spouse or next of kin, they have to have a general description of the assets of the estate. So any real estate, motor vehicles, or other assets over $10,000. So you have to have say what those assets are and assign a estimated value to them, just to give the court some idea about the assets that exists, and to give other heirs and people who are receiving this petition an idea about what assets they expect to be in the estate. And then you have to give a statement about what you've done so far to search for assets. And once you have a probate open, you have a lot more ability to do searches, but there's always some searching that can be done before a probate's opened. All right, so those are the changes to the petition itself, the petition for letters of administration. All right. And then now the legislature made sort of a disfavored class of people who can be personal representative. And so these are people who have no legal connection to the deceased. So they're not related to the deceased. They're not, have served some fiduciary role with the deceased. So no legal connection, although this could be like a really close family friend. It could be somebody's in-laws. So it could be somebody that has a very real connection to the family, but not a legal connection to the family. So for people that fall into this category, they cannot open a probate until 90 days after the date of death. They can only get paid from the estate, so they can't be getting paid from anywhere else. They cannot purchase, acquire, or receive any assets from the estate. So this has to be like a completely disinterested person. The court will not grant them non-intervention powers. This was something we were able to get before on almost all probates, where the court doesn't supervise or oversee selling assets, distributing money to beneficiaries, paying creditors, things like that. But without non-intervention powers, a lot of that is going to have to be, motions made to the court to sell an asset, or motions made to the court to make distributions or to pay creditors, things like that. This type of person cannot be in this role more than 2 times a year. So this is directly getting after people who do probate to make money, try and find deceased people with no probate open and go open a probate and pay themselves to do that. Um, and then they have to post a bond. And this is the part of the reason for having that summary of the assets and the value of the assets is the court knows how much the bond, the value of the bond that they need to post. There's one exception to the rule about not receiving assets of the estate in that someone can receive or purchase assets from the estate if the court approves it. So there's a process for giving 14 days notice to all other sort of interested parties. And as long as it's not a breach of the administrator's duties to the other heirs, then the court can approve them to purchase or receive assets from the estate. If they receive assets without going through that process, though, they can be sanctioned for up to 3 times the value of the asset and any other sanctions or remedies that the court wants to impose on them. So definitely following that process would be it'd be a requirement for someone who's in that position. All right, then the legislature also made additional people who cannot be the personal representative. So previously, someone who had a felony can't be a personal representative. There was a relatively few restrictions on who could do that. So now they've added minors, which I guess I assumed was already part of the law, but it wasn't. So minors can now not be personal representatives. Anyone who's had their letters of administration or letters testamentary revoked in the last 24 months. Anyone who's been found by a court or administrative agency to have engaged in acts of dishonesty, theft, or breach of fiduciary duty in the last 36 months. And then strawmen, someone acting in concert with someone who would not be able to be a personal representative, or someone who's going to buy or acquire assets from the estate. So if the personal representative is acting on behalf of someone else or in someone else's interest, then they also cannot be a personal representative. All right. The next few here deal with sort of immediately after a probate's open, and then things that happen toward the end or could happen after a little while into a probate. So there's 2 new notices that have to go out. So the first one is a notice. It's called the Declaration and Report of Personal Representative Confirming Notice to Third Parties. It's a mouthful. So the statute has the form of the notice in the statute. So this isn't something that has to be drafted. It's the legislature has done that for us. So it has to be mailed out and filed with the court within the first 30 days after appointment. And it has to include the names, addresses of any heirs or beneficiaries, anyone who's receiving something from the estate. And it has to identify the details of the search for those people. So this could be the same as was in the petition, or maybe it's slightly updated after, after someone becomes personal representative. Maybe they further try to find more heirs, but probably that's already done. And then it has to include the date and manner of notice to the parties. So if it was mailed, if it was personally served, when it was mailed, things like that. All right, the second new filing is the Declaration and Report of Personal Representative regarding estate financial accounts. So any personal representative, this is in intestate, so administration of estates. If you open a new financial account, bank account for the estate, you have to file this notice saying, what the financial institution is, who are the signers on the account, the date it was opened, and that has to be filed with the court within 30 days after the account's opened. All right. There's always been a provision that allows heirs and beneficiaries to require the personal representative to file a report with the court that deals with assets of the estate, debts of the estate, sort of a status update. So there's a new the requirements changed where any interested party, so this would be heirs at law, beneficiaries, um, creditors could be in this category. So the court has defined interested parties. There's a definition of it, but it's, anybody who's has an interest in the estate, they can require the personal representative to file a report, and that report has to be filed within 90 days. If it's not filed within 90 days, the person can, on motion to the court, can have the personal representative brought in, and the personal representative has to testify under oath verbally as to the same facts that should have been put in the report. So assets of the estate, creditors, debts, progress report, kind of a thing. And the court can sanction somebody if they don't show up, or if they lie during that hearing, or if there's sort of repeated failures to do the reports. The court can sanction them. And then if that happens, well, if they have to show up in court, then there's a court order, and that order has to be given to all of those interested parties afterward. The next one is that, and this has always been the case, that we try to close probates within a year. That's sort of the standard. Is if it's going to take longer than a year, you should tell the court why it's going to take longer than a year. But they've added a new provision where the court can order a probate to be closed within 24 months, and you can show the court reasons why it shouldn't be closed, and that can be extended. But the default is that the court can tell you need to close the estate by this date, and unless you have a good reason that it can't be done, then you need to get it closed by that date. And then the last one, which is this is designed. These last three, I think, are all designed for having more transparency in a probate. So there's interested parties can get information, because it's sort of probate's like this black hole of information where there's relatively little information that a personal representative has to give people, and there's always people wanting more information about it. So this third one is meant to be able to easily find if a probate has been filed. If somebody is in that disfavored class of personal representatives, where they don't have a relationship to the family, they have to wait 90 days, all of that stuff. They have to open the probate in the county where the deceased lived, or if they don't live in Washington, they can open it in the county where an asset is. So currently with probates, we can open them in any county in the state of Washington. So oftentimes that's King County because they have a good filing system. Or, I'm in Snohomish County, so sometimes we open them in Snohomish County because we can walk into court and do it maybe a little quicker. But for somebody who's looking for a court filing of a probate, they're going to be looking in, the most likely place is the county where the person lived. So now if you're filing a probate and you're in that disfavored class of people, then you have to file it in the county where the person lived. So it's sort of a good change for making people be able to find these probates and things more easily. So I think a lot of these changes probably overall are good. They make some situations difficult. They cut down on people doing probates for reasons maybe they shouldn't be doing probates. If somebody sees 2-foot tall grass in someone's yard, and they say, gee, I want to buy that house. I wonder if the owners are dead. And then they start doing they figure it out, and then they start a probate because they want to sell themselves the house. That person probably doesn't have the best interest of the heirs, as their top priority. Their top priority is they want to buy the house. Other, like I mentioned earlier, there's an industry of doing probates for profit, and oftentimes when the person whose personal representative is not, have they're not a beneficiary or an heir of the estate, they could make decisions that are more in their self-interest, for profit that they're going to make off of doing the probate or saving time. So they might be inefficient, and that results in less money going to the heirs. These rules can also make things more difficult. In the case of a, close family friend or someone's in-law who wants to become personal representative of an estate, they're now in this disfavored group of people. And so the probate is going to be a little bit more difficult, a little bit more expensive because, every thing that needs to happen now, for selling assets or paying creditors or closing the estate, all of that has to happen by motion to the court and having a hearing and scheduling it out. So, there's more drafting of motions that has to happen. There's more time showing up in court that has to happen. And so it results in, more expensive probate, for the estate. So I think the legislature on whole was trying to, and probably did a good thing, probably stopped, people who were abusing the system. But there's the downside of it is there are people who, all of the family members might agree that they are the best person to be the personal representative, but they fall into this disfavored class of people. So, they just have to work around that. Maybe the law gets amended where all of the heirs, all the interested parties um, can waive these rules and allow them to have non-intervention powers and allow them to serve without posting a bond and save, make a more efficient probate. Right now there is no process for waiving that in the statute. Maybe courts will let heirs waive this. Maybe the law will change to allow them to waive it. It's hard to tell right now. It's a pretty new law, and these things develop pretty slowly after new laws come out. So those are some of the changes. There's a few other ones in the new law. They all go into effect about 6 weeks from now. And it's going to affects again mostly probates that are without a will, so looking for letters of administration. So if you are going to be appointed personal representative, you need to look at these things and see how the petition has changed, the additional notices you need to give, and just stay on top of it. And certainly here at Beresford Booth, we help clients with this every day. So navigating the process of opening a probate, navigating the process of giving all of the notices, the two that we talked about today, and other notices that have to get sent out, and then the rest of the process of the probate, dealing with assets, dealing with creditors, and ultimately making distributions and closing the estate. So if you need help with a probate, we're here to help people out. So feel free to give us a call. Well, that's it for today. So I hope that was quick and informative information about this new change coming up. So thank you.